sa case doctrine, the principles cited. So, as a repetition lang, elements of theft and estafa. Theft is committed by any person. Theft is committed by any person who, with the intent to gain, but without violence, against or intimidation of persons, nor force upon things. Okay, shall take personal, it should be personal property of another without the latter's consent. If committed with grave abuse of confidence, the crime of theft becomes qualified. The crime of qualified theft under Article 308 in relation to Article 310 of the Revised Penal Code requires the confluence of the following elements. So again, kapag sinabi nating theft, there is a taking, it is committed by any person by taking the property of by taking the personal property of another without the latter's consent. Walang consent ng owner. And there is the intent to gain. And lastly, there is no violence against intimidation of persons nor force upon things. Nagiging qualified theft kapag there is the presence of grave abuse of confidence. And now, elements for estafa. Elements for estafa involving unfaithfulness or abuse of confidence under Article 315, Section 1B of the Revised Penal Code are the following: that money, goods, or other personal property is received by the offender. Na-receive ng offender yung money, goods, or other personal property. Na-receive ni offender in trust, or on commission, or for administration, or under any other obligation involving the duty to make delivery of or to return the same. So, ito na yung tinatawag nating juridical possession. Bakit? Bakit may juridical possession? Because the property was given to the offender in trust, on commission, or for administration, and with the obligation to make delivery thereof. Another element is that there be misappropriation or conversion of such money or property by the offender or denial on his part of such receipt. Kinonvert yung property na receive ni offender in trust, kinonvert niya into his or her benefit, or nag-deny siya na hindi niya daw na-receive yun. Hindi daw na-receive. And the third element is that such misappropriation, conversion, or denial is to the prejudice of another. Siyempre, na-prejudice yung owner. Binigay niya nga dun sa offender, tapos sinabi ng offender, hindi niya daw na-receive or na-convert na niya or na-misappropriate na. And there is, last element is that there is demand by the offended party to the offender. So, in this case, the remedial law, this is now the remedial law. In the field of remedial law, allegations not in the information. It is fundamental that every element of the crime. So, it is very important kapag sa criminal law, sa information, filing of criminal complaints, the information must set, dapat nakalagay dun lahat, yung elements of crimes. In order to avoid surprise on the part of the accused and to afford them the opportunity to suitably prepare their defense. Kaya nga, dapat yung information natin kompleto. All the elements must be complete kasi babasahin niya ng accused, the defense counsel. And from that information, they will prepare a defense. Kapag hindi yan nabasa nila, and the information is not properly alleged, there will be a violation on the constitutional right to be informed the nature and cause of accusation filed against the accused. No matter how conclusive and convincing the evidence of guilt may be, An accused cannot be convicted of any offense unless it is charged in the information on which they are tried or is necessarily included therein. So, ito na yung ini-emphasize ng Supreme Court. No matter how conclusive, kahit gaano naka-convincing, kahit gaano ka-strong evidence ng guilt ng accused based sa mga evidence, pieces of evidence na na-present, an accused cannot be convicted of any offense. Hindi siya mako-convict kahit sobrang lakas ng evidence. Kapag it was not charged in the information. Sobrang lakas ng evidence against the accused. But those evidence gathered are not properly alleged in the information. No matter how conclusive and convincing the evidence of guilt may be, an accused cannot be convicted of any offense unless it is charged in the information on which they are tried or is necessarily included therein. So, kung ano yung na-charge sa information, anong nakalagay, ano yung mga alegasyon na nakalagay sa information, dun lang. Dapat ma-prove yun ng prosecution. Kapag iba ang na-prove ng prosecution during the trial, then kung ano yung na-prove nila, that's void. It cannot be considered by the court in making its judgment. The court must only convict or make decision based on the information charged and also based from the proof made by the prosecution. Si prosecution, i-prove niya yung mga allegation ng information. Yun lang. And the court must make a decision based on that trial made. So, kung ano yung na-prove ng prosecution, dun lang. The proof must be based on the information. Kung naka-allege, kung nakalagay, example, nakalagay dun sa information is theft. Tapos na-prove nila may qualified theft pala. Na-prove ng prosecution may qualified theft. Now, the court will not make a decision convicting the accused on qualified theft. Hindi niya pwedeng gawin yun. The court cannot convict a person on qualified theft. Bakit? Hindi yun naka-allege sa information eh. Dapat, the court must make a decision based on the information charged, based on the information filed, and also based sa na-prove ng prosecution in line with the information. So, dun lang. Pero kapag na-prove nila is iba, hindi yun pwede. So, again, paulit-ulit talaga ito. Paulit-ulit din sinasabi ng Supreme Court and paulit-ulit ko din tong i-explain kung na example na charge is sa information nakalagay dun is theft, tapos na-prove ng court, na-prove ng prosecution na merong qualified theft, the court must base on the information. The court must make a decision based on the information. It must not make a decision based kung ano yung na-prove dun during the trial. Kasi it's a constitutional violation on the part of the accused. Hindi niya alam. Hindi niya alam na yun pala yung na-prove ng court na may qualified theft siya, na in which nakalagay dun sa information is only theft. So, mako-convict lang siya dapat sa theft, hindi sa qualified theft. Kahit gaano kalakas yung evidence pointing to qualified theft, pero nakalagay dun sa information is only theft, dun lang talaga. Dun lang siya mako-convict sa theft, not sa qualified theft. So, more importantly, the allegations of facts constituting the offense charge are substantial matters and accuse a right to a question there. Accuse their conviction based on facts not alleged in the information cannot be waived. Again, more importantly, the allegations of facts constituting the offense charge are substantial. Siyempre, yung ano yung naka-allege the alleged facts, the allegation of facts constituting the offense charge are substantial matters. Substantial yan. Kaya nga, si prosecutor, dapat asserting niya lahat, nilagay niya lahat, complete all elements of the crime. Kasi kung isa lang dun, hindi niya nalagay, it is subject to motion to quash because the offense charge, because, ano pa yan, the facts alleged does not constitute a crime. Okay? So again, dapat in terms of crimes, dapat naka-allege lahat ng elements dun. Kasi kapag isa dun ang hindi na-allege, one of the elements is not alleged in the information, then it will be subject to motion to quash. Ma-quash yung information on the ground that the facts alleged does not constitute crime. The charge against Arlene, sa kaso ni Arlene Romorosa, the charge against Arlene is designated in the information as qualified theft. Nilagay dun sa information na qualified theft. Yet, the Court of Appeals and the Regional Trial Court convicted Arlene of estafa. In this case, ito palang Arlene Romorosa, this is a case na nakalagay sa information, qualified theft. Tapos, na-convict siya ng CA and RTC involving estafa. Na-convict siya, nakita nyo? Sa information, nakalagay dun na filean siya ng case on the ground of qualified theft. Pero na-prove ng Court of Appeals and Regional Trial Court na conviction siya ng estafa involving unfaithfulness or abuse of confidence. Hindi yun pwede. That decision of the Court of Appeals and Regional Trial Court must be disregarded. Hindi yun pwede. Kasi naka-allege sa information is qualified theft, hindi estafa. So this is the Supreme Court is always reiterating. Thus, the court deems it necessary to discuss first the distinction between these two crimes. So, again, qualified theft is different from estafa. Kung sa information nakalagay is qualified theft, then the accused cannot be convicted of estafa. Magkaiba yun. Dapat ma-reform or ma-change, ma-amend ang information. From qualified theft, gawin nilang estafa. Para to give time for the accused, the defense counsel, to prepare a counter on the information file. So, that is the case of Arlene Romorosa versus People of the Philippines.